On September 30th, 2011, Lanny Horwitz was fatally shot at his residence in Jupiter, Florida, a home he shared with his ex-wife, Donna Horwitz. Upon the arrival of the initial responding officer, Christy Coleman, Ms. Horwitz remained silent and physically unresponsive to questioning. This behavior, specifically her pre-arrest and pre-Miranda silence, became the focal point of a landmark constitutional debate regarding the privilege against self-incrimination. The trial of Ms. Horwitz began in early January 2013, centered on a volatile domestic relationship and financial disputes as the primary motives for the homicide. Specifically, the prosecution argued that Ms. Horwitz had grown resentful after spending approximately $200,000 of her own savings to support Mr. Horwitz's lifestyle. Throughout the proceedings, the state characterized her initial silence at the crime scene as substantive evidence of her consciousness of guilt. Ultimately, on January 17, 2013, the jury in the Palm Beach County Circuit Court found Ms. Horwitz guilty of first-degree murder, resulting in a mandatory sentence of life in prison without the possibility of parole. Following the verdict, Ms. Horwitz challenged the state's use of her silence, leading to an appeal. On November 3, 2015, oral arguments were heard before the Florida Supreme Court in Tallahassee. During the session, Assistant Attorney General Luke Napolitano presented arguments for the state.
May it please the Court. My name is Luke Napolitano, and I represent the state of Florida, who is the petitioner in this case. This case is about 3 questions asked by an officer comforting a family member after a suicide call. Do you need anything? Do you want a bottle of water? Were you in the room when the gun went off? The district court below held that respondent's failure to answer these questions was inadmissible based on this court's decision in Hoggins, and it erred in doing so.
Didn't actually, in looking at the trial in this case, the prosecutor went far beyond that he asked the detective, who wasn't even there, and she did invoke, shortly after those first 3 questions, she actually did ask for an attorney. So from then on, the state did not try to get that in, right? You know, you
Right.
couldn't get in when she asked for an attorney. Yeah. But they asked questions like, well, did she say anything to detective? There was another guy there. Did she ever say? So they kept on asking questions about not just that she didn't say anything to those 3 questions, but they went broader. Are you familiar with the record?
Yes.
You agree that that happened?
Yes, that's part of redirect testimony of Detective Frank, yes. Yeah.
Okay, so what's your idea is that, you're not saying it's harmless?
No.
Okay,
the state's argument is that constitutional rights are not implicated by the introduction of pre-Miranda silence.
Go ahead.
I'm a little concerned conceptually with the arrest and where this would take us if we follow what you're urging. It seems to me that if that's the point that we're going to, in all situations, use as the point of demarcation, it just seems to me that law enforcement could, as a practical matter, just delay the arrest and lengthen any interrogation that's going on and say, well, we haven't arrested you yet. I'm troubled by just that the conceptual thought of using that as the sole demarcation. I do understand the importance of that event, but to just say that's the be-all, end-all, it just really concerns me. I mean, help remove my concerns. Could you please, with that scenario?
Right. The demarcation is not really at the point of arrest. This court in Traynor v. State held that the right of silence applies when a person is in custody and under interrogation. In custody is when a reasonable person believes they're under arrest, not when the officer tells them they're under arrest. Interrogation applies when a reasonable person believes they're being asked questions that accuse them of a crime, not when a police officer says, now I'm starting an investigation. And those are objective tests. So there's very little way a police officer could manipulate that. So it has to do with whether the person believes, a reasonable person would believe at that point that they were in custody under interrogation.
Well, that's not for this is not for when Miranda is to be given, because that's the issue of custody. Your position, at least in the brief, is that if she had invoked the first question, do you want a bottle of water, when she doesn't answer. And again, and this is different than some other cases, because she really never answers anything. And then she has to put on that she really couldn't hear. But that she would have, if she wanted to remain silent, she needed to invoke and say, well, Officer so-and-so, although I'm shocked and my husband just died and was killed and I saw that, I would like to invoke my right to remain silent.
Yes.
So the idea is that a sophisticated defendant would know the first time that no matter what the circumstances, that a police officer comes over to question them, that they ought to invoke their right. An unsophisticated defendant who's in shock gets the detriment of being told, or the jury being told, that they didn't answer because they must have known they were guilty.
Right.
How is that good policy? I guess that's my question, is that this person, and so let's be clear, she didn't take the stand. So we're not talking about whether she could have been impeached. Well, you didn't tell that story when you first spoke to the officers. This was used as a theme that they're using her silence as consciousness of guilt. So we're not even getting into the evidentiary issue, but as a constitutional right, her right to remain silent was there from the beginning, was it not? She had that right.
No, her right to remain silent does not apply until she's in custody under interrogation, or she expressly invokes her right to remain silent.
Well, so then what would be so why does she have a right to invoke Miranda? You're saying, if she had said, no, I am invoking my right to remain silent, you're saying, no, they could have continued to...
No, if she invoked her right to remain silent, then the silence would not be admissible past that point.
Well, so then she did have a right to remain silent. She just, and you know, the question here, and with the dissent in Salinas, is that she arguably invoked it because she remained silent.
Well, under Salinas versus Texas, the plurality opinion expressly held that a person must expressly invoke their right to remain silent.
I think it's not confused. I think the police can continue to question up and until the person invokes their right.
Right.
That's what you're saying.
Yes.
Right. So the Jupiter Police Department could have just kept asking the questions until she says, "Look, I want a lawyer," or something like that, and then it stops, or she's in custody or something like that. So
Yeah,
until
that's under the objective facts.
Don't you think there's something, not quite right here when the police start off being at what looks to be very solicitous? Do you need some water? Those kinds of things, and then they pop in a question: did you see your husband get killed?
Well,
And the person says nothing in response to that. And you want us to say that you can now say that shows consciousness of guilt. She said nothing to the police at any point, did she?
No.
And so all of that is consciousness of guilt.
Yes.
And, it seems to me that if she had maybe started answering some questions and then stopped, you might be in a different position. But to have never said anything to the police as they're talking to her, I'm having a hard time accepting that.
Mr. Napadano attempts to justify the prosecution's use of Ms. Horwitz's silence by asserting that her constitutional protections had not yet been triggered at the time of the encounter. The concept at issue is pre-Miranda silence, which refers to a defendant's refusal to speak to law enforcement before they have been formally arrested or advised of their rights under Miranda v. Arizona. As the United States Supreme Court held in Salinas v. Texas, the Fifth Amendment's privilege against self-incrimination does not generally protect a person's silence unless they explicitly invoke that right during a non-custodial encounter. However, this federal standard is often superseded by state-level protections. In Florida, the state Supreme Court has held that Article 1, Section 9 of the Florida Constitution provides a broader shield for a citizen's silence, regardless of a formal invocation. Because Ms. Horwitz was in her own home and had not yet been placed under arrest, the state argued that her choice to remain silent and place her fingers in her ears was a physical observation the jury could lawfully consider. Mr. Napadano further contended that this behavior, combined with her subsequent request for an attorney, constituted constituted evidence of consciousness of guilt. In the state's view, an innocent person would have naturally spoken to the police without any hesitation.
She testified that she was there to comfort the family members after a suicide call. So all these questions were just a matter of comforting her. Yeah.
Then she started working on the case itself.
No, I disagree. Like, were you in the gun with the room is not necessarily, it's not a crime to be in a room when a gun goes off.
But if that it doesn't mean there's a crime to be in the room, then how do you translate that into, it shows she was a consciousness of guilt?
Because in this case, when the security guard arrived, it looked like a suicide. Lanny's hand, the gun was positioned so it was kind of pointed to her, and respondent said to Garcia, "I knew he would do this, so it looks like a suicide." And she comes in at trial and says, after it's determined that this was a murder, well, it had to have been Radley or a hitman. So the question becomes, why didn't she say anything when she was the one in the room when her ex-husband was killed?
Let me ask you this. I mean, I'm trying to picture in my mind how this happened. Ms. Horowitz is standing by a car outside the house.
She's sitting in her car.
In the car with her son.
Yes.
And that's when the police officer from Jupiter, Christy Coleman,
yes,
approached them. And she asked those 3 questions. I mean, I'm trying to picture those questions. Was it something like, are you all right? You need a bottle of water? Or what were you in the room when it happened? I mean, how was there an interval between each one? Or they just rapid fire questions? And she is standing there, I believe she had her fingers in her head, in her ears, not listening. How did that happen? We don't have a tape, so we don't know.
No, we don't.
But you know more about it, and it was a trial. Perhaps the defense counsel can tell us.
I mean, well, Officer Coleman, she testified she was there to comfort them, so we have to look at it like that. She was there to comfort the respondent, and she's like, you need anything,
so the question about whether you were in the room when it happened, the purpose of it was to see, are you upset?
Yes.
And that's the reason for it?
Yes, that's the reason, yes.
Okay. All right. So you have no way of knowing how fast was it just one at a time type questions and some time between, or the rapid fire questions?
It's not reflected in the transcript, no, but...
Well, Officer Coleman testified in court, and obviously her testimony would reflect that.
Yeah, I mean, she testified she was there to comfort them, so we have to look at it like she was asking comforting questions.
Okay, and this testimony, this silence, the fact that she did not answer the question, it was used as substantive evidence in this case. So it was during the state's case in chief, it was presented to prove her guilt. The fact that she didn't answer when she was asked if she was in the room.
Yes, it's part of
that prove guilt?
It's part of the circumstances of the case to show that it was her that murdered her ex-husband and not her son, who was really the only other possible person who could have done it.
One reasonable explanation would be that she was in a state of shock, right?
Yes.
That would be an explanation.
That's what the... Yeah.
Did the defense ever offer any kind of explanation in terms of that?
I believe so, yes. And that was.
And how did they do that?
I believe it was either through direct or cross that Officer Coleman testified that she looked like she was in a state of shock.
But to offer other evidence puts the defense in a very bad position, doesn't it? Like then they're trying to then present the defendant's communication that's then subject to impeachment and potential problems with her testimony and right to silence.
I mean, well, it's part of having a defense, I guess. And then the jury.
I'm sorry, I didn't understand you.
I guess it's part of presenting a defense, and then the jury can decide.
But see, that's the whole problem, and I want to follow up on what Justice Paulson said. She is being penalized for exercise. She has a right not to incriminate herself, right? That's an absolute right. And she doesn't take the stand, okay? And we're going to distinguish that if she took the stand and gave another version, that Hagen says it can be impeached, pre-arrest, pre-Miranda silence. But here, she doesn't take the stand, which is her absolute right, but she's penalized because the only way for her to explain why she didn't respond was for her to put on a defense. And that's shifting the burden away from what the state has to do and her right. It is impairing her constitutional right to remain silent. And the courts, like the Pennsylvania Supreme Court cases post-Salinas, have explained that's exactly why this is a constitutional violation. Does the state doesn't see that as being a problem?
No, because the burden is always on the individual to exercise their right to remain silent. It's not the burden on the state. It's the burden on the defendant.
Justices Labarga and Justice Quince challenged Mr. Napadano's position by questioning the inherent ambiguity of Ms. Horwitz's silence, particularly given that the state's own witness had testified that she appeared to be in a state of shock. This raises a critical issue under Section 90.403 Florida statutes concerning the probative value of such evidence. Probative value refers to the capacity of evidence to prove a relevant fact in dispute. In Florida, silence is often deemed insolubly ambiguous because it may stem from trauma or shock rather than a deliberate desire to conceal the truth. Consequently, such silence does not establish guilt, and its admission risks being substantially outweighed by the danger of unfair prejudice, which unfairly influences the jury without a sound factual basis. Justice Pariente reinforced this concern by noting that the state's position penalized Ms. Horwitz for exercising a constitutional right, thereby shifting the burden of proof. By treating her silence as substantive evidence of guilt, the prosecution created a penalty that unconstitutionally burdened her right to remain silent. This could place the defendant in the position of having to take the witness stand solely to explain her silence, compelling her to rebut a conclusion of guilt that arose from her exercise of a protected right. The justices further questioned whether the state's reliance on the federal standard in Salinas versus Texas conflicted with the independent state grounds provided by Article 1, Section 9 of the Florida Constitution, which shields individuals from being compelled to testify and has historically been interpreted more broadly than its federal counterpart.
Almost like in the old, when did you stop beating your wife? That would require someone to testify, I never beat my wife. Same thing here. I asked her, were you in the room when this happened? Silence. And now they introduce that as substantive evidence, not impeachment, substantive evidence. That requires her to take a stand to explain why she didn't say anything. You don't see a problem with that?
No, I don't. The U.S. plurality of the U.S. Supreme Court didn't either.
Well, here's the other question I have, because we spent most of the time on the constitutional issue, but there's an evidentiary issue. And in the brief, the last line of the summary of the argument says, pre-arrest, pre-Miranda silence should not be categorically barred under evidentiary rules, as its probative value is not always substantially outweighed by the prejudicial effect. So there seems to be a concession that there can be cases where the prejudicial effect outweighs the probative value. Now here, her silence, I mean, we had a case, we have Cardona, which had an issue where maybe it's not, it's a different situation. But here, Officer Coleman testified she was in shock. She testified to that. She apparently had hearing loss, which they had to put on. It's her silence, as we said in Hoggins, based on Hale, is ambiguous. Yet you are using it, you, the state, are using it throughout the case and in closing as substantive evidence of guilt. Why isn't this case a case where the probative value is outweighed by the prejudicial effect because it is not clear that her silence was indicative of her consciousness of guilt?
Well, first of all, the state agrees that normal evidentiary rules apply to substantive evidence 401, 403, but you have to, under 403, the prejudice has to substantially outweigh the probative value. And the probative value here is part of the circumstantial evidence that demonstrates that it was her and not Radley that committed the murder. It's part of the evidence, that includes the blood on her foot and the DNA.
She would have said, well, she's in the car, which she was told to wait in the SUV with her son. And there's certainly, there is certainly evidence that they could point to Radley, who had the $500,000 life insurance policy in his name. But she's there with her son. She's in shock. Let's just say that something happened and she saw her son kill her husband. She's going to say, oh, I'm in shock because I just witnessed my son who's sitting here kill my husband?
Yes.
That's what that's what the state was really arguing, is she would have to say that.
Yes, that's what the state argued, yes.
Mr. Napadano attempts to characterize Ms. Horwitz's silence as admissible conduct rather than a protected constitutional right, pushing Justice Pariente to question whether its admission violated Florida's prohibition against using a defendant's silence as substantive evidence of guilt. Substantive evidence is offered to prove a fact directly an issue rather than to challenge a witness's credibility. As the Florida Supreme Court established in the landmark case of State versus DeGilio, the prosecution is generally barred from commenting on a defendant's right to remain silent. Under the DeGilio standard, such a comment is considered a high-risk error, placing the heavy burden on the state to prove beyond a reasonable doubt that the error did not contribute to the verdict. The admissibility was further examined through the lens of Florida Evidence Code Section 90.403, a mandatory balancing test. Under this provision, relevant evidence must be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. This concern was compounded by the circumstantial nature of the case. A third party was introduced as culpability evidence regarding a $500,000 life insurance policy that provided a motive for a different suspect, their son, Radley Horwitz. After the prosecution finished his arguments, defense attorney William Gray Tesh had the opportunity to start his oral arguments.
Good morning. Gray Tesh on behalf of Donna Horwitz. This is a case about silence, or more specifically, the meaning of silence. This court's held silence is ambiguous. A person may stand mute for many reasons, a variety of reasons, numerous reasons.
Well, that would go to the evidentiary issue, which seems to be, to me, quite strong in any event. But would you go to the constitutional issue? And would you agree or disagree that Salinas out of the U.S. Supreme Court, although it's plurality, seemed to suggest that silence as a constitutional right you've got to expressly invoke your right before the state is prohibited from using it against you. So do you agree we have to go under our state constitution?
Correct. Under the principle of federalism, this court is required to look at the state
Although
constitution.
it does seem like Salinas if this was Salinas here, is a better case for using it, where he was talkative, he answered all this question, and then just when it got to something about the gun, he doesn't say anything.
Right.
Here you have I think you have a stronger case than Salinas. I wonder if this case was up on whether they wouldn't see that here was a woman that was actually invoking her right to remain silent. And one other question about that. After Officer Coleman is asked these questions, Detective Frank, at some point, she actually does ask for an attorney. Do we know in the sequence of things how quickly in time that was after this initial interaction with Officer Coleman? Do you know how long after it happened?
I think the record does not reflect the exact time.
But it was still while they were both in the SUV.
I believe they were both still in the SUV, so it was a short time after. I don't know how long.
So doesn't that speak to the argument that in this case anyway she was actually invoking her right to remain silent?
Yes, if you look at the dissent in Salinas, they talk about that by actually remaining silent, could be invoking. Of course, that's not what the plurality held. But see, the facts are so different, right? The record facts in this case show, number one, she didn't answer questions because she couldn't hear. And number two, she was in shock. So how could you expressly invoke under those circumstances? In Salinas, that person voluntarily went to the police station. He voluntarily answered questions.
But you don't really want this, well, you may be due for your client to be case specific. We're asked a question whether pre-arrest, pre-Miranda silence, or let me see how the certified question reads. You must know.
Right. It's under Florida law, whether pre-arrest, pre-Miranda silence can be used against the defendant if they don't testify at trial.
As substantive evidence, because that's the key. In Hoggins, we said it can be used as if they testify.
Correct. But I think that's under the Florida Constitution. There's still the 90.403 analysis in every case. And because silence is so ambiguous, citing United States versus Hale, this court held in the Hoggins case, it's
not always so ambiguous, because it does seem to me that in Salinas it was pretty unambiguous, that he was not he was not answering that question. If he had said, I am now invoking, when you asked me that question, I'm invoking my right to remain silent, they
Right.
couldn't have used it, correct?
Right, but the difference there was he heard it, he understood it, and there was also nonverbal communication, the clenching of fists and things like that. So factually, it's completely different.
Mr. Tesh argued before the court that the state's reliance on Salinas versus Texas was misplaced because the factual circumstances were materially different. In Salinas, the defendant voluntarily participated in a non-custodial police station interview and remained silent only when asked a specific incriminating question. This standard cannot be fairly applied to a person who has just experienced the shooting of a spouse in her own home. Under the insolubly ambiguous doctrine, silence in the immediate aftermath of such trauma is legally unreliable, as it may be a product of shock, grief, or mental paralysis rather than a guilty mind. The justices also examined State versus Hoggins, which established a clear procedural boundary. Under Hoggins, if a defendant chooses to testify, the state may use prior silence to impeach their credibility. However, the state is prohibited from introducing silence as substantive evidence of guilt when the defendant remains silent at trial. Because Ms. Horwitz did not testify, the state's use of her silence amounted to an unconstitutional penalty for exercising a protected right.
I'm concerned also about the closing argument. The prosecutor says the defendant at that time had no right to silence. You can take that as an evidence of consciousness of guilt when she does not speak to Luis Garcia or Christy Coleman or to Radley. I take it these are the police officers. There is no right to remain silent at that time. You can take that as evidence of consciousness of guilt. Is that did she have a right to remain silent at that point in time?
Yes, she did.
And how would that be expressed? I mean, is it something that all citizens are supposed to know? Or because legally the officer doesn't have to read the Miranda rights until she is in custody. You agree she's not in custody yet?
Correct.
Right. She's just sitting there waiting for the police officers to do their thing inside the house, and then Coleman comes out and starts talking to her, asking, is she okay, that kind of thing. So how would a citizen know that they have the right to remain silent throughout this whole process if nobody tells them? They don't have to tell them until they're in custody. How do I know? How does anyone up here know?
Well, I would submit that a lot of people don't know what their rights are. I don't think they would know, even if they were told. Like if this court were to follow Salinas, let's say the cop is talking to somebody in perhaps a consensual encounter, perfectly legal for him to do. He talks to them, they don't want to talk. And then he says, well, Mr. Jones, I understand you don't want to talk, but not saying I'm going to arrest you, but if I do and you get prosecuted, the judge can tell this jury they can use that evidence against you, your silence, as substantive evidence of guilt. Now, let's talk about this.
My concern, I guess what's bothering me intellectually is that we have volumes of law books where we have basically gone back and forth on what is custody, when is someone in custody for Miranda to have been invoked. We have all that, and we have pondered for that for years. And yet here I see that all a police officer has to do is ask you, oh, by the way, were you the person who shot him? And if the person doesn't answer, then that comes in as guilt.
Right.
And just like that, it just seems to me, it seems odd to me. That's just me.
Well, there's also serious implications of other rights. For instance, in a consensual encounter, where the Fourth Amendment would be protected, protect a person, for instance, if they refuse to answer questions of police in a consensual encounter. The Fifth Amendment would not. Because if the silence could be used against them later in trial, the Fifth Amendment would not.
You as a defense lawyer, you've been a criminal defense lawyer for, what, 25 years, not more?
Not quite that long, but
This feels like it, right?
yeah.
I've known you for at least that long, but anyway, let me ask you this. I mean, when you try these cases, if you were trying this case, how would you, if this came in as substantive evidence, the prosecutor introduced as silence, what would be your strategy to combat that? What would you have to do to disprove that? as a defense
Well,
lawyer?
the first strategy would be, I'd seriously have to think about putting Donna Horwitz on the stand, right? And Justice Perriente, mentioned that, has the absolute right to remain silent and not testify. That right is also being affected today potentially by this court.
So that would be your first move, to put her on the stand to explain?
That would certainly be one. Another thing we did, we called an audio specialist in to say that she was half deaf. I mean, there was 48% hearing loss in both ears, and the record facts show that she did use a hearing aid throughout the trial and still didn't hear everything. But I certainly would think about putting the client on the stand a whole lot more, because you got to explain it.
Were you the trial lawyer?
Yes, Judge.
Okay, because you also filed a motion to, this wasn't, the judge was fully aware, as was the state, there was a motion to suppress. You actually did
Yes.
take the position that she was because she was told to stay there, that she was
Yes.
in custody. And you're not trying to argue that.
That is
But
true, Judge.
what the prosecutor says, and what Justice Labarga read, the defendant at that time had no right to silence. That's not true. That's actually not true, correct?
Correct.
But what the answer now is, oh yeah, you have a right to silence, but you've got to know you have that right, and you got to expressly invoke it for us to honor it.
Right. And
So
your
again, a
concern-
career criminal who is in some kind of sophisticated scheme.
Bernie Madoff. Someone more sophisticated.
I don't know.
You're-
He didn't
know what
talk?
you- right.
I don't know.
No, I know what you're getting at. Like the sophisticated people, there's one standard for them and there's one standard for everyone else.
Well, especially someone who's in shock because whether she killed him or he was killed himself, which I guess is now not possible, or Radley killed him, she's definitely upset. Everyone said she was screaming and upset, right?
In shock. Right. And to answer also Justice Polston, when he was speaking with Mr. Napadano, you had mentioned about the shock. Did the defense offer an explanation? And if you look at the record fact in Volume 6, starting, I think it was page 1055, maybe a few lines or a few pages down from there, the state in their case in chief said she was in shock. It wasn't something that we brought forward. It was brought out in their case in chief.
The state itself offered it.
Mr. Tesh responded to the state's argument of the fact Ms. Horwitz was not in custody, so legally the officer didn't need to read the Miranda rights by highlighting a fundamental contradiction within the state's case. The prosecution had introduced evidence that Ms. Horwitz was in a severe state of shock, and the defense further noted her documented 48 to 50% hearing loss. Mr. Tesh argued that under Section 90.403 of the Florida Evidence Code, such evidence is insolubly ambiguous. It is legally impossible to distinguish between a calculated decision to remain silent and a physiological inability to respond due to trauma and physical impairment. Furthermore, Mr. Tesh warned that adopting the state's position would create a constitutional catch-22 for citizens. If silence during a pre-arrest encounter is treated as evidence of guilt, citizens are penalized regardless of their choice, creating a chilling effect on public cooperation and violating the fundamental fairness guaranteed by the Due Process Clause.
Let me ask you, you explained very well the distinction between the facts in this case and the ones in Salinas, the U.S. Supreme Court, on the U.S. Constitution grounds. Let me take you to the facts of that case, Salinas.
Yes, sir.
That you went through a few moments ago. Under those facts, how would you apply the Florida Constitution to those facts? How does that come out under the Florida Constitution?
How does it come out?
Because what you're arguing here for today, isn't it? Perhaps, are you arguing that the Florida law, the Florida constitutional outcome should be different than the U.S. Constitution? Is that your argument?
Correct, Judge.
All right, so if that's your argument,
I think that's required.
how do the
Judge.
facts under your argument apply to under the Florida Constitution on your argument here today?
I think any voluntary statements that he made, so they knock on the door, hey, will you come with us? Yeah, I'll go with you. We want to eliminate you for Prince. He goes to the police station. Any voluntary statements that he made would be admissible. But the moment he is silent, they can't comment on that silence. I think that's pre-arrest, pre-Miranda silence, unless he testified at trial, and then the trial judge has to do the 90.403 analysis.
So you would depart from the U.S. Supreme Court's analysis for Florida purposes on that point, on the silence issue.
Yes, sir, and I think this court is required to, because if you look at the Declaration of Rights, what's the purpose? Individual freedom and autonomy. And this court has held in Richter, Inc., the Fifth Amendment version, if you will, the Due Process Clause, Article 1, Section 9, must be broadly construed and independently construed.
Now, is there a reason why we should do that under the Florida Constitution other than the fact that we just don't like it, what the U.S. Supreme Court did?
Because it's right. Here's why it's right. Justice Perriente, she also spoke about, you're treating different people differently, right? Also, people are going to have even more distrust of law enforcement than they would already. Police are going to purposely delay Miranda and delay arrest in order to get some confessions, admissions by silence. That's exactly what's going to happen. And it's not right.
So U.S. Supreme Court got it wrong. We should get it right, apply Florida Constitution. That's your argument?
That's correct.
Okay.
Mr. Tesh urges the Florida Supreme Court to address the constitutional question of pre-arrest silence directly, rather than resolving the case through constitutional avoidance, the judicial preference for deciding cases on narrower, non-constitutional grounds. Justice Polston questioned whether a departure from the federal standard in Salinas versus Texas was legally necessary, pressing the defense on why Florida should not simply adopt the federal floor established by the United States Supreme Court. Mr. Tesh argued that departing from the federal standard was a necessary exercise of new judicial federalism, contending that if Florida permitted the state to treat pre-arrest silence as substantive evidence, law enforcement would be incentivized to tactically delay formal arrests, and the public would lose more faith to corroborate with the police as witness. This tactic would allow officers to observe a suspect's reactions in high-stress environments without the burden of Miranda warnings, later presenting that silence as a tacit admission. He further warned that without a bright-line rule, the outcome of any given case would depend on the abuse of discretion standard applied to individual trial judges, leading to judicial inconsistency. By establishing a clear constitutional standard under Article 1, Section 9, Mr. Tesh argued the court would recognize the privilege against self-incrimination as self-executing from the moment of police contact. This would bring uniformity to the system, ensuring that a citizen's fundamental right to remain silent is protected equally across all Florida courtrooms, regardless of whether a formal arrest has been triggered.
Well, there was, first of all, and I don't know, again, did the U.S. Supreme Court address the very strong evidentiary basis, which is in some ways to me linked with the constitutional basis, which is this, and I'm reading now from how the Utah Court of Appeals expressed it. If an individual is questioned by the police, that individual is compelled then to do one of two things, either speak or remain silent. If both the person's pre-arrest speech and silence may be used against that person has no choice that will prevent self-incrimination. And that is what the essence of the right to remain silent is you are not compelled to give testimony that will incriminate you. Yet what we're really saying is that Ms. Horowitz was either compelled, even though she was in shock and couldn't hear, to give her explanation of what happened in that room, or forever be damned by being silent.
Right.
Now,
just immediately assert the trial defense.
Whether it's hard to know what the U.S. Supreme Court actually said, because again, two of the justices would actually say that the right to silence doesn't even apply to pre-arrest situations. Is that what
right.
Justice
I think
Thomas?
That was Scalia and Thomas in the concurring in the decision or the result only. I think that was the case, Judge.
Did the U.S. Supreme Court address the evidentiary issues of,
Not to my
of
knowledge,
a balancing?
Judge.
And as the U.S. Supreme Court said in other cases, that the states, under their Constitution and evidentiary principles, can look to their own history. And again, whether it's right or not, this court has, since Traylor and in Rinkerdink and then in Hoggins, has interpreted our right broader.
Right, because it's the federal jurisprudence is the floor, not the ceiling. Right, and I think even under a 403 analysis, Justice Colston, go back to that. I don't know that it was raised because I didn't see it in the decision, but This case is very strong, even under the 403 analysis. So even if you have an issue with the constitutional analysis, I don't see how under 90.403 this could have happened. This could have been admissible because silence is so ambiguous. She's in shock. She can't hear. It's not even relevant to prove any material fact or disprove any material fact. So without the relevance, you don't even get to the 403 balancing.
Would you address the evidentiary issue first, or?
No, I would address the constitutional issue first because I think it has broader implications for individual freedom and autonomy.
Why should we address the constitutional issue if it need not be answered, and this case can be resolved totally on an evidentiary basis?
Because, well, you know, that's a good question. I don't know the answer to that, sir.
I'm looking to you for the answer.
Okay.
Not the question. I came up with the question. It's your
Right.
turn to come up with the answer.
I plead the fifth.
You can expressly invoke it.
But that's because I know what my rights are.
Well, we'd have to, I mean, I guess if we didn't address it, the 4th District, because the 4th District does it on both grounds, we would have to just say we're not reaching what the 4th District says. So it would sort of keep, I don't know if the state would prefer that as a result, it would keep the 4th District's reasoning as to the Florida Constitution, because they did it on both bases, right?
I'm going to waive my Fifth Amendment for a second and take a stab. If you were to come up with a bright line rule, pre-arrest, pre-Miranda silence, not admissible unless you take the stand on a constitutional basis. First of all, it alerts all the trial courts, this is what the law is. It also alerts the police officers, this is what it is. If it's on an evidentiary basis, then the trial judge has to weigh every single case, and depending on which trial judge you get, you're going to get a different result. So, uniformity.
Can you address in this case, we mentioned the closing argument comment, but it seems that the state went farther than even if it were somehow a narrow rule, because they did ask about, well, she never said anything. They go through all the people she never said anything to, including police officers. Now, it is correct that on retrial, if there is a retrial, that what she says or doesn't say to Garcia.
Right, to civilians, they're not state actors, doesn't apply.
Right, but when you're asking a police officer questions about, she never said anything to this person, I mean, I don't even see how that is appropriate questioning, even if there was some other rule, because you're now putting the police officers is almost testifying that she just remained silent, and then nobody knows, well, she actually did invoke her right to remain silent, because you can't talk about that. So it gives this false idea that she never told anybody the story, when really shortly after all this began, she did ask for an attorney, and the jury doesn't know that. So it seemed to me that that was even more unfair in this case because of those kinds of questions.
Right, I would agree with that. You can argue it better than me, Justice Farrington.
Justice Pariente encapsulated the fundamental concern of the oral argument by observing that if both a person's speech and their silence can be used against them, the individual is trapped in a constitutional catch-22. In this scenario, the individual is left with no available choice to protect against self-incrimination, rendering the privilege under the Fifth Amendment. Mr. Tesh built on this by urging the court to recognize that Florida's privilege against self-incrimination must function as a self-executing right. This would shield a citizen from the moment law enforcement arrives, regardless of a formal arrest or Miranda warnings. He argued that requiring a person to verbally invoke their rights before they have been explained places an unreasonable burden on citizens in distress. By closing the Miranda-less gap that the state sought to exploit, the court would ensure that the sanctuary of the home and the silence of the accused remain constitutionally inviolate.
I think, first of all, the state would ask this court to address the certified question in this case. Otherwise, the constitutional rule set forth by the 4th District is binding on all the trial courts, unless another district court happens to conflict with it. The second point I'd like to make is I disagree with Mr. Tesh's answer to Justice Polston's question about Salinas. In Salinas, the defendant voluntarily went to the police and waived his right his right to silence in answering the police officer's questions. And once he fell silent, it was incumbent on him to expressly invoke his right to remain silent. His right to silence was implied by his failure to answer one question.
So you think there are enough facts there that are different that it can be distinguished from this case?
Well, I guess the state's position would just be that the defendant, Salinas, would have to expressly invoke his right to remain silent, even under the Florida Constitution. And so in conclusion, I guess the state would ask this court to answer the certified question in the negative. Hold that the district court erred in holding respondent's pre-arrest silence was inadmissible, and to quash and remand to reinstate the respondent's conviction for first-degree murder.
On May 5, 2016, the Florida Supreme Court ruled that Donna Horwitz was entitled to a new trial, affirming a lower court's decision to overturn her 2013 murder conviction. The court held that the prosecution's use of her pre-arrest silence as substantive evidence of guilt violated the self-incrimination protections of the Florida Constitution. On June 6, 2017, following retrial, Ms. Horwitz was found guilty of second-degree murder and sentenced to 32 years in state prison, a significantly reduced outcome compared to the mandatory life sentence without parole she had originally received. This case illustrates the critical importance of a police officer and prosecutor's duty to follow the proper investigation process to maintain a fair and cohesive lawful procedure. During the case, Mr. Napadano enforces that Ms. Horwitz had not a constitutional right due to the situation and was allegedly consciously guilty. Mr. Tesh, on the other hand, argued that would be a constitutional violation of the Fifth Amendment right. Even though Ms. Horwitz was still convicted later in her retrial, the law enforcement must follow the right procedures, constitution, and statutes to guarantee an unbiased judicial system. By highlighting this unfair investigation and trial, Mr. Tesh showed the justices the problem that might emerge between the public trust and the law enforcement in future occasions. Now, let us know if there is a case you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so that we can help promote a more informed society.